Many- I met Dr. Hall. That tell me I need to hurry up. I met Dr. Hall many, many years ago when, as a high school student in Boston Public Schools, I attended a program here at Northeastern Law School that Dr. Hall was instrumental in convening for minority students interested in the law. It was in significant part due to the support and encouragement that I received from Dr. Hall here at NUSL and to the NUSL students that I felt that I belonged in law school and that maybe, just maybe, I could be a lawyer. Fast forward to today, after years of legal practice, even though I may not look like it, the years of legal practice. Thank you. I am now teaching and mentoring students right here at NUSL, where it all began. Talk about coming full circle. I hope that I can be as impactful and inspirational for my own students as Dr. Hall has been for me. Dr. Hall has received numerous accolades and awards over the years. He is a prolific legal scholar, having written, taught, and lectured nationally in the areas of civil rights, social justice, U.S. Constitution and race, legal education, diversity, leadership, and spiritual values and professional life. He's even written a book on the intersection between law and spirituality. A man of deep faith and incredible humility, Dr. Hall lives his faith and his values. And that's evident in the tireless work that he has done and continues to do in service to others. He is a visionary leader, an educator, and a builder, not just of institutions, but of people. His list of accomplishments is way too extensive to recount here, so I encourage you all to Google him. But I think he would probably list among his most significant accomplishments his marriage to his life's partner, Dr. Marilyn Brathwaite Hall, and his role as a proud father of 3 children, his 2 daughters, amazing daughters, Sakila and Kiamsha, and his son, Rasan Hall, Noosa's own Rasan Hall, who needs no introduction, who's been following in his father's footsteps admirably. I would add that his living legacy is not just his family, but his colleagues, his staff, faculty, students, friends, and all of us whose lives he's impacted in such a powerful and positive way over the years. We're blessed and so proud to have him here with us today. Would you all please join me in welcoming Dr. David Hall. Thank you.
Oops. Better. Stand up one. You want to do it the way you want to do it? You could put it here, and that may be better. Good. Based on that wonderful introduction from Antoinette, you may think that I'm the keynote speaker. I am not. We are honored to have someone here who can speak and will speak on this wonderful topic that you see in front of you. But I am honored to be here. This is really a special opportunity to share opening remarks at the 30th anniversary of the Valerie Gordon human rights lecture. I am not going to eat up the time that has been given to me, recognizing and introducing all of the wonderful individuals who are in this room. So many of my colleagues who I worked with when I was here, former students who are here. It is really a pleasure. The existing Balsa students who are keeping this tradition alive. Words really cannot capture how special that is for me. But I do want to recognize the members of Valerie's family who are here, Chris Lamar, Faluke. They have been supporting and coming to this event since its inception. And I think that says a lot as well. I want to take personal privilege and recognize my wife, Dr. Marilyn Braithwaite Hall, who supported me and supported this law school, especially Balsa students during my time as a law professor and my time as dean. And I do want to, as Antoinette indicated, recognize my children, Rasan Hall and Sakile Braithwaite Hall. They both are present here. And I want to publicly let them know how proud I am of the type of individuals they have become. I was only able to convince one of them to attend Northeastern Law School, but I am still proud of all of them. This is a magical day for the law school and for me in so many ways. One of those magical moments is the result of this special law school, an institution that has helped to transform lives as it was being transformed. And I was honored to be associated with the law school and the university for over 24 years. A shining example of this institution's magic is the person who introduced me. As she indicated, in approximately 1986, during my first year as a professor, I proposed to the administration that to increase the diversity of students at the law school, we needed to reach out to high schools and expose students of color to careers in law. And one of the high school students who attended that day-long program was Antoinette. She stood out because during a moot court presentation where Professor Denise Cardi Bonilla, who she mentioned, and I served as appellate advocates, Antoinette volunteered to serve as one of the judges. Her questions were so probing and thoughtful that she became the buzz of that day. And though she did not attend Northeastern Law School, she admitted many years later that that conference transformed her life and made her believe that law was a career she would pursue. And now she is a faculty member at that same law school that sprinkled magical dust on her dreams. But the magic was not Antoinette. It is that process of believing without evidence, trusting without proof, and standing on the unrealized and unlimited potential of others. When individuals and institutions are consistently willing to engage in this process, we create magical moments and we also change lives. The next magic I want to remind us of is the core purpose for this gathering. I remember in 1993, a couple of months after becoming dean, I received this dreadful call from Chris Lamar informing me that Valerie Gordon, his wife, had passed away. These two very brilliant and dedicated students had recently graduated that May and were ready to launch their careers and to put into practice those skills that they learned here and those values that they brought with them and were refined here. Valerie never had that chance. I also remember Professor Hope Lewis coming into my office a few days later and proposing that we create a human rights lecture in Valerie's honor. Whether intended or not, what I believe was behind Hope's suggestion and my acceptance was a deep belief that the values of change, resistance, and the empowerment of the marginalized must be enshrined and remembered. So this commemoration is more about the values that lived within and were manifested by Valerie Gordon than about Valerie. That deep moment of sadness that Chris, myself, and so many experienced that moment has been transformed into 3 decades of commemoration and commitment to those values that resided within Valerie and so many others. What you must understand is that there was no endowment to pull from to create this lecture. It was supported by the law school through its existing funds and have been supported that way for 30 years. You must also understand that the law school has been honoring a student who was one of the leaders of a protest within the law school. That protest led to changes in the curriculum and the culture of this law school. So when we convene this lecture every year, it is a reminder that it is the presence and spirit of students that has helped to transform this institution for the better. That is what makes it special. We create magic when a law school chooses to celebrate a student for 30 years who never practiced law, but practiced love and hope and chased justice as she walked this campus. This day is also magical for me because on April 3rd, 37 years ago, I walked into an Easter Sunday service and saw an empty seat next to this beautiful woman I had been watching for over 2 years. By sitting down next to her, my life was raised up and forever changed. Marilyn and I celebrate this day, this magical day, each year, just as we celebrate our wedding anniversary. So I want to thank all of you for coming to our party. All of these magical moments that I have mentioned are not the magic of tricks and sleights of hand. They are the magic of believing, the magic of creativity and values. We create magical moments in our lives and the world when we use the power each of us has to create change right before our eyes, to remove human pain and suffering and replace it with healing and hope. We create magic not when we pull a rabbit out of a hat, but when we pull justice out of the clutches of injustice. In this present climate where for some human rights are valued less and diversity not at all, then we become wizards when we are courageous enough to embrace and defend those values. That is the Northeastern's law school mission that I remember, to be a light in the midst of this nation's darkest moments and darkest tendencies. In the words of the famous singer and actress Andra Day, We each have the magical power to paint a picture we've never envisioned and to build what we've never seen before with bricks we were never given. That is Northeastern at its core, and that is Valerie Gordon at her core. Thank you.
Take this one. Not quite as tall as the last speaker, but good work. Hi, everyone. My name is Isaiah Kazunga. I'm a 2L and currently serve as the secretary for BOLSA. It's my honor to introduce this year's Spirit of Valerie Gordon Book Award winner. Each year, the BOLSA e-board has the honor of selecting a recipient for the Spirit of Valerie Gordon Book Award. Student contestants submit an essay that centers on social justice, and the purpose of the award is to both encourage and celebrate Black students' human rights scholarship. To honor the award's 30th anniversary, we intentionally created an open-ended prompt to encourage as many students to submit as possible. The task was to submit a piece of writing which spoke to a social justice issue that the author was passionate about. In a time of rising fascism, attacks on student protesters, and human rights rollbacks across the globe, we wanted our essayists to submit heartfelt and personally compelling pieces. Each of the submissions that we received honored the spirit of Valerie Gordon and her fight for social justice. We chose our winner because her essay, which examines the disproportionate impact of the child welfare system on Black families, combined a strong choice of topic with beautiful prose and polish. Please join us in congratulating the winner of the 30th annual Spirit of Valerie Gordon Book Award winner, Jalon Fowler.
Definitely not as tall as either of the last two speakers. Good afternoon. You have to love events where we have a critical mass of people who know how to behave at conferences and lectures like this. I so appreciate it. And you all know what I mean. My name is Elizabeth Ennin, and I am the director of the newly launched Center for Global Law and Justice. And on behalf of the center, I want to thank everyone here in the room today and everyone joining us on Zoom for your being able to be with us today. Thank you for being with us for the launch. Excuse me, that was the last event. For the 30th anniversary of the Valerie Gordon Human Rights Lecture. For decades, this event was co-hosted by the program the Program on Human Rights in the Global Economy, or FERGI as we lovingly called it. I'm happy to reassure you all today that FERGI is alive and well, and it now exists as an initiative of the Center for Global Law and Justice. The center is extremely proud to co-host this event with the Kemet chapter of the Black Law Students Association. This year's co-chairs of BALSA, Nefemi Awosika and Sydney Palmer, are very, very busy people and somehow miraculously find the time to help with hosting and planning this event. Nefemi, Sydney, you give so much to this law school's community, and we are extremely, extremely lucky to have you. It has been such a pleasure working with you. Thank you so very much for everything you've done to make this event a success. I would also like to thank Professor Antoinette Copley, who does bring the magic. It is such a joy to work with you. It has been a pleasure and an honor. I don't even know where to begin. This event would not be nearly as special as it is this year in particular without the magic that you bring to this. Thank you so much. It's a joy. As you might have noticed, Dean James Hackney is not here with us today, but he asked me to pass along the fact that he feels very sorrowful about not being able to join us. He mentioned to me that the Valerie Gordon Lecture is one of his favorite events of the year, and he so wished he could have been here, but alas, he is out of town. I know I miss him today, and I know all of us here in the room miss him. How extraordinarily lucky we were, given those circumstances in particular, that President David Hall, the dean who presided over the very first Valerie Gordon Lecture so many years ago, was willing to step up and fly from the Virgin Islands, no less, to Boston to join us here for this event. President Hall, I had the privilege of being a student in your contracts classroom 19 years ago, a few feet from here. It was a privilege to be a student of yours, and it's a privilege to have you here with us today. Thank you so much. We are grateful to you for making the trip, and we are honored by your presence. Thank you for making this anniversary event even more special than it already was. We're very grateful. Thank you. The Gordon family. The Gordon family has been enriching this law school community for over 30 years. Christian, Lamar, Faluke, I don't even know what to say. It was so very kind of you to make time in your schedules to travel here to be with us today in person. We're moved by your presence here today. We're honored by your presence today. Thank you so, so very much for being here. It means the world. I'm sorry to report that the Reverend Dr. Carolyn Gordon, who had plans to join us today, was unable to do so because of a medical issue. I know she would have loved to have been here. I can tell she would have loved this moment, this event, the energy in this room. We're very sorry that she couldn't be here, but we hope to see her in the future. I'd also like to acknowledge the many family and friends of both Valerie Gordon and Christian Lamar who are joining us today over Zoom. Thank you all very, very much for being with us today. It is now my pleasure and honor to introduce our keynote speaker for this year's event, Professor Anne Orford. Professor Orford's home base is Melbourne Law School in Australia, where she is the Melbourne Laureate Professor and Michael D. Kirby Chair of International Law. This spring, Professor Orford is at Harvard Law School, where she is visiting professor and the John Harvey Gregory Lecturer on World Organization. Professor Orford researches and teaches in the areas of, among other things, international law, climate change, international dispute settlement. Her research has garnered a long list of awards. I'll mention just one here. Her fifth and latest book, International Law and the Politics of History, from Cambridge University Press, was awarded the 2022 European Society of International Law Monograph Prize for Excellence in International Law Scholarship. Because of her expertise, she has been asked to serve on a wide range of important roles in various institutions. Just for example, she is a member of the Permanent Court of Arbitration in the Netherlands, a fellow of the Academy of Social Sciences in Australia, a past president of the Australian and New Zealand Society of International Law, and an expert advisor on climate change to the Pacific Islands Forum. Professor Orford's work is extraordinarily influential. She has presented over 50 named public lectures, keynote speeches, and plenary addresses. How wonderful for us that the impressive list of her speeches will now include the 30th anniversary of the Valerie Gordon Human Rights Lecture. Professor Orford will be speaking to us today about the role of human rights in climate activism. Please join me in giving her a very warm welcome.
Well, good afternoon, everyone. It's a great honour to have been invited to be here this afternoon to celebrate the memory of Valerie Gordon, not someone that I met, but already having been in the room, I feel a little bit that I know something of her spirit. And listening to all of you, hearing about her background as a journalist, as a law graduate, as an activist, as an advocate for social justice and human rights in the US and internationally, And clearly, as a builder of movements, a movement that seems to have carried on for so much longer after her passing. So today I want to build on that legacy, take the opportunity that you've given me with this invitation and this honour to think about the relationship between human rights law and social movements in the specific context of climate action. So I've called my talk The Role of Human Rights in Climate Activism, but really I'm interested in the different roles that human rights plays in climate activism. And thinking about, in terms of movements, the fact that human rights is just one part of a broader movement. It is not the only tool in the toolkit, and indeed in some cases it may not be the right way or the kind of exact tool that's needed in a particular moment. So I want to try and think about the place of human rights in a broader field, a field of law, a field of politics, a field of protest. And indeed I was delighted to hear that protest is the theme of the prize that was given this afternoon. That is where I'm going to take the last part of the talk, but not where I'm going to begin. So I'd like to say a little in opening about where climate change fits in a broader story of international law. Climate change and international law being the subject that I'm teaching currently at Harvard. And climate change is a topic that is occupying an increasing amount of time and energy right across the field of international law. So initially, we used to look particularly to the UN Framework Conference on Climate Change, the Convention on Climate Change, and the treaties that have been negotiated since. I'm sure you're very familiar every year with hearing about the conference or the parties or the COPs meetings where far too little is done to address climate change. And so that is really the framework that once would have been talked about if we were talking about climate change and international law. But of course, there's been an enormous and much deserved criticism of the slow pace of those negotiations, and increasingly a turn to international law for solutions, other parts of international law. And indeed, there are parts of international law that are causing part of the barrier to climate change. We would think about investor-state dispute settlement as one area where investors are able to sue states if they take climate action because of the loss of profits it causes or the kind of stranded assets. So climate change then is in a sense becoming an issue that we see many other global issues refer to, and indeed it's becoming something of a frame through which other issues are addressed. And that's partly driven by all sorts of actors who want to use climate change as a way to bring their issues to attention. So climate change is now in many ways becoming an issue and a language through which many other debates are addressed in international law. And as with any language, it can be used to say many different things, different ways of framing, of thinking about climate change, engage different audiences. They suggest different policy interventions. They suggest different legal interventions. So my broader work, research and teaching is engaged with trying to think about the different ways in which climate change is becoming an object in many different fields of international law. So you can see the many different ways in which it appears in international law as an issue in relation to specific climate treaties, but also the law of the sea, investment law, trade law, human rights, which we'll be talking about today, but also security, securitization of climate change, where departments of defense and militaries were really out in front of every other part of many governments in thinking about climate change, and the international criminal law regime with climate change and ecocide now being proposed as a potential crime to join the Rome Statute. So I'm interested then, thinking about this range of questions about what visions or forms of law or enactors are enabled by framing climate change in one way rather than another, and what are the costs or benefits of framing it in terms of one regime rather than another. And here, of course, my interest is in, so what do we gain when we frame climate change as a human rights question? Who's enabled? Who's empowered? Who may not be enabled or empowered by framing it in that way? And what are the costs and benefits of that? And so I want to think about who's entitled to speak, who counts as an expert, what techniques and forms of political action are enabled, what forms of knowledge are constructed, what relations are created, and who do the outcomes empower? And I don't think those answers are something we can just assume. So in my work, I'm very interested in looking at actual cases. So empirically, who is making use of these kinds of mechanisms? Who does speak in this language of human rights about climate change? And how does that differ, for instance, if we think about human rights, rather than, for instance, taking this issue to the Security Council of the United Nations, when security experts get to tell us what is the right answer to climate change, but young people who are affected have absolutely no way to kind of take part in those discussions. So that's the international law context. There is, of course, a very significant domestic law context. That's not my area, so I'll leave that to people in the audience who have some comments about that later on. This is also, of course, taking place in a broader political context. As I was teaching for the past 7 weeks, every day that context would change. So I'm not going to try and keep track of that particular story here. Suffice to say, the US is not participating in many of the climate change initiatives at the moment. But we are seeing a use of a language of crisis, a language of emergency. In many ways, of course, it is a crisis. We are in a climate emergency, but that language can lend itself to different kinds of politics. Very often, the language of emergency, the language of crisis, leads us into a non-democratic way of proceeding. We look for efficient, speedy executive actions, and we may find even kind of eco-fascist responses, authoritarian responses, rather than democratic responses. When we think about the proper forms of law, ways of responding to climate change, we also hear people worry about courts playing too much of a role in social transformation. Do we not want to give too much power to courts? Do we want to keep it in the hands of people? Can we trust courts to deal with an issue like this in a way that includes all of us? And those questions then, of course, go to the broader issue of what we understand the relation between law and activism or movement politics to be. So with that in mind, I'm interested in trying to think about earlier critiques of human rights, indeed even some earlier critiques of what ended up happening with civil liberties when the movement became more about law and less about politics, an argument that somehow turning to human rights is depoliticizing, takes the politics out of the story, and ask how do those critiques relate to the current situation? So do those critiques match the situation we find ourselves in now, or are we in a different moment? And I think something interesting is going on with human rights. I think, in fact, climate action is changing human rights as much as human rights is changing climate action. So I want to pay attention to exactly what is going on. And I'm going to look at a few cases, a few examples, just to get a feel for that, and then finish up by suggesting that it still needs to be more attention given to climate protest and the repression of protest, because I think that is a very real barrier to more participation. So the last question then, what role can and should human rights play, in particular in contributing to political, economic and social transformation, those values of change, resistance that we were talking about earlier, is what I'd like to kind of finish with. But I am then going to talk about one piece from the early 2000s that really synthesized a set of critical concerns about international human rights at a moment really of kind of US superpower dominance, when in many ways human rights was being used to kind of project out into the world, tell other people how to think about human rights, and really not being incorporated domestically. And I want to think about that argument by a colleague at Harvard, David Kennedy, in a very famous piece that was an enormous shock back in the early 2000s when it was first published, called The International Human Rights Movement, Part of the Problem, 2002, when Professor Kennedy encouraged us to think about human rights pragmatically. Now, that's a hard thing to do with something that we kind of think about as a matter of belief, something that we see as representing particular values. But his argument was we need to think about how human rights is being used in particular cases and who it's being used by. So what are the costs and benefits of using human rights as a tool in a particular case? he said it's difficult to think about that because often the benefits are very clear, but the longer term effects aren't. We need to always think about human rights in comparative terms. What is it displacing? What other language, what other mechanism, what other political or legal form might we be referring to? And does thinking in terms of a particular field like human rights distribute power or status away from others? So let me run through very quickly 6 of the points he made that I want to then use to think about how climate change and human rights are being brought together today. So if you're my students, at the end, I would ask you to tell me which of these you think still apply. I won't do that, but we will be thinking about that in any case, because I want you to think critically about, does this critique still operate? If not, what does that tell us about what's going on, the way human rights is being used? And as a spoiler, I think many of these points don't still apply to human rights in the way it's being used in relation to climate change. So it's interesting to think about what's going on. But what I think the value of this call is still the call to be pragmatic, to think pragmatically about this relation between particular forms of law and particular forms of politics. Okay, so the potential problems, very fast, 6 of them. First, does human rights occupy the field? Does it take too many institutional resources and energy around projects that can be framed as rights and make other projects seem ideological or political? So if we can't frame something legally, does it look too ideological? If you can't frame something as a human right, does it go unattended? And does it mean we lose other languages, duty, responsibility, collective commitment? Second, does it narrow the problem too much? And in particular, does it narrow the problem too much to make us just focus on governments and states rather than other groups, other collectivities, other actors? I think something interesting is going on there, but we'll wait and see. Third, does it generalize too much? So do we have to imagine people in terms of very black and white roles, victim, violator versus bystander? And does it delegitimize people who can't fit into those roles, whose ethical situation is more complex? Fourth, does it particularize too much? And in particular, is it too individualistic? Do we think about people out of their community, out of their broader context? Do we think just about emancipation between the individual and the state and not the group? Do we make distributive arrangements less readily if we think in those terms? Does it bring along too much of an ideology of Western liberalism with downsides of alienation, loss of faith, loss of spirituality, loss of relation to the environment, and too much imperial sensibility? And finally, does it promise neutrality in the middle of a battle? So if we're in a struggle for resources, does human rights make it seem like we're in some other kind of situation? So his conclusion in 2002, was whatever has been the history of human rights, we do not know its future. Perhaps these difficulties will be overcome. So the question is, have they been? And is the way that climate activists are using human rights part of that process? Okay, so the rights turn then in climate action has really been very marked. Beginning in 2015 with dissatisfaction with the Paris Agreement, then the Trump 1 administration withdrawing from the Paris Agreement, great frustration with the slow pace of negotiations and the refusal of powerful emitters to step up and make binding commitments. And after that, we saw an enormous expansion of cases. There are now more than 3,000 climate litigation cases brought or ongoing, according to the Sabin Center's database. Most of those are domestic. Only about 5% are in international court and tribunals. That's what we'll be looking at. They're brought under many forms of law: tort law, constitutional law, corporate law. We'll be looking at human rights law. And there is, of course, a counter-surge in litigation, which we could spend another whole afternoon talking about, brought by corporations bringing SLAP suits, so strategic lawsuits against public participation, claims against protesters seeking damages for protest, fossil fuel companies seeking compensation for losses to their investments in the international system. Again, none of that will be talked about here, but it's all part of this story. So I'd like to look then at 3 cases that have been brought using human rights in the past few years and look at some of the ways in which they are shifting away from an individualist approach, an approach that doesn't think about distribution, an approach that is alienated from the environment, an approach that's alienated from spirituality, and try and think about what's going on. So we'll start with this petition, which may be very familiar to a lot of you, brought by 16 youth activists, filed on the first day of the UN Climate Action Summit in New York in September 2019. You might know the activist in the top left there, Greta Thunberg, reasonably well-known Swedish woman. So these children at the time were from Argentina, Brazil, France, Germany, India, the Marshall Islands, Nigeria, Palau, South Africa, Sweden, Tunisia, and the US. And they brought their communication under the optional protocol to the Convention on the Rights of the Child. All of this text is up here because my Australian accent will make it hard to follow me, but you can see what I'm saying if this is proving difficult. 2 things to note here: that the communication has to be submitted by someone claiming to be a victim who's within the jurisdiction of a state, and the communication's inadmissible if all domestic remedies haven't been exhausted. So those 2 things are going to be important. The petitioners said that the respondent states, and there were many, Argentina, Brazil, France, Germany, and Turkey, and you'll notice they're not the states in which the children live, had breached their obligations under this Convention on the Rights of the Child. And this convention is the most ratified human rights convention. And I think I'm right in saying there's only 1 state that hasn't ratified it. I'll let you guess who that is. So they claimed that the respondents had failed to comply with their obligations under the convention, and all of the respondent states had ratified the Convention on the Rights of the Child and the Paris Agreement. And they said that the states had recklessly caused and perpetuated life-threatening climate change, and then therefore had failed to protect these young people, even though they weren't based in their countries, and that those rights that were threatened included their right to life, health, culture, and the best interests of the child. And they said that the respondents had the obligation to prevent foreseeable climate change, to cooperate to protect children, to apply the precautionary principle even if the science wasn't clear, and to ensure intergenerational justice, and that in failing to do that, they had violated their rights under the convention. Now, all of the states said, you have no jurisdiction to hear this claim. These children don't live in our countries. They haven't even tried to bring these cases domestically. You don't have any right to hear the case. And the Committee on the Rights of the Child, in the end, agreed they didn't have authority to hear the case. But they made a couple of very interesting moves on the way to getting there. First of all, they said, we do have extraterritorial jurisdiction. So states can be held responsible for failing to protect the rights of children in other countries because those children are affected by actions that are taken in that state. Now, that's an enormous stretch in international law. That's a very new thing that only the Inter-American Court had already said. And so the Committee on the Rights of the Child has stuck with that argument. Second, they said that the young people had standing. So they were initially and significantly affected by climate change such that they had standing to be victims under the convention, but that the matter was inadmissible because the children had not sought to exhaust domestic remedies. They hadn't tried to bring the case domestically. That is a very standard feature of much of international law, that you have to at least try and bring the case domestically. So the children said, well, we wouldn't have been able to, these courts were never going to hear it, and we won't be children forever. But they said, that's too bad, you have to give it a shot. And you can imagine these courts and tribunals are getting a little worried because there are a lot of people in the world, and if climate change is a human rights issue for everyone in the world, and everyone can bring their claims, those poor people working on these courts and tribunals will be very busy. So they're all trying to figure out, where's the limit here? So this was their limit. You have to at least attempt to bring the case domestically. So it was a very high profile claim back in the days, Twitter, may it rest in peace, that one of the young people, I think it probably was Greta Thunberg, now I've forgotten it, but it sounds like her, doesn't it, said, this is a delusional ruling and turn of events. One of the press releases from the lawyers said that the committee turned its back on children. As it's a committee for children, clearly that wasn't the look they were going for. And so interestingly, they then announced that they would write a general comment, which is an advisory document, in which they would make a statement about children's rights and the environment with a focus on climate change. And they specifically said that the reason for doing that was the Saatchi communication. Okay. There was an enormous involvement of youth groups, children involved in this. And you can see here the reference to 16,331 contributions from young people who made contributions to what this general comment should look like. And it did end up in finding that children have a right to a clean, healthy and sustainable environment, not mentioned anywhere in the convention, that could be implied from the convention, and that it was directly linked to rights such as the rights to health, life, adequate standard of living and education. Okay, case number 2. So this case is brought by 8 Torres Strait Islanders. The Torres Strait are a group of islands between Australia and Papua New Guinea in the Torres Strait, so part of Australian territory. And the case was brought by 8 Torres Strait Islanders in their own names and on behalf of 6 of their children. And they argued that the effects of climate change were threatening the islands and marine and coastal ecosystems, resources, life, livelihoods, and unique culture of the Torres Strait Islanders. So they bring this case to the Human Rights Committee, which is set up to oversee and monitor implementation of the International Covenant on Civil and Political Rights, to which the US is a party, I'm happy to say. So they said that even small increases in sea level rise could have an immense impact, were having an immense impact on life, had already caused, not something going to happen in the future, had already caused flooding, erosion, coral bleaching, reef death, decline of seabed grasses, decline of nutritionally and culturally important marine species, destroyed buildings, destroyed graveyards, which is happening all over the Pacific, where people's, the graves are being inundated, saltwater intrusions into soil and groundwater so that it was no longer possible to drink and garden. And they predicted severe future impacts as well on traditional ways of life and subsistence and culturally important living resources. And they claimed Australia had failed to take mitigation and adaptation measures to combat the effects of climate change. So mitigation, in the language of the Climate Change Treaty, means taking steps to reduce greenhouse gas emissions, to stop the situation getting any worse. And adaptation means taking measures to at least protect people from the climate change that's already happening. So the Torres Strait Islanders are saying that the Australian government had failed at both. It had failed to stop emitting, as Australia is a major emitter, and that it wasn't taking action to protect the people of the Torres Strait by building seawalls, by helping to take the salt water out of the water and so on, that not enough was being done. So importantly, this is the first time that we see a human rights body find that yes, the matter not only is admissible, but that a state has violated its human rights obligations because of these failures. And the authors argued that Australia had violated, amongst other things, the right to life, the right to private, family and home life, and the right to enjoyment of culture belonging to a minority Indigenous group. And the committee found that Australia had indeed violated the right to private, family and home life and the right to enjoyment of culture, though not the right to life. They said in terms of the right to life, 10 to 15 years was still though that 10 to 15 years was the amount of time left in which it may no longer be possible to live on those islands, that was enough time for something still to happen. That apparently isn't yet imminent, but those other violations were found. So a violation of private family and home life, a failure to protect private family and home life because of a failure to discharge a positive obligation to ensure there wasn't intense, serious degradation of the environment, and violation of the right to enjoyment of culture belonging to minority Indigenous groups. And significantly, they also required reparations to be paid by Australia or to be made by Australia, including adequate compensation, meaningful consultation in terms of the needs of Indigenous people, continued implementations of measures to ensure safe existence on the islands, effectiveness, and preventing serious violations in future. So you'll note that all of those reparations relate to adaptation. Nothing was said about mitigation. Australia firmly argued that it shouldn't have to be responsible for answering about its mitigation obligations to a human rights body. That was a matter for climate treaties to which no obligations had been made. And so therefore this wasn't a matter that could be dealt with before a human rights court or tribunal. So I'll come back to that in just a minute. But just a reminder that this part of the world has really been at the vanguard of climate action since at least the 1980s. So here we were talking about a petition to a human rights body, but it's also the small island states, including in the Pacific, that pushed to keep loss and damage at the UNFCCC negotiations from 1990. They pushed to keep 1.5 as the limit for temperature rise at Paris, 1.5 to stay alive. Students from Vanuatu led the push for a climate advisory opinion from the International Court of Justice. The coalition of small island states, including some states from the Pacific, brought the advisory opinion to the International Tribunal on the Law of the Sea. Palau led the move to have climate treated as a security issue before the General Assembly in the 2000s. And in September last year, Vanuatu, Fiji, and Samoa made formal submissions to amend the Rome Statute of the ICC to recognise the crime of ecocide. So we hear a lot of talk about leadership of the international community, but I think it's very important to remember that much of that leadership has been coming from this part of the world, and sadly not that bit of it. Okay, the last case I want to touch upon is the Klima Senyorinen case. So a very different group of people here. So these are the senior women, often referred to as the Swiss grannies. So this case is brought before the European Court of Human Rights. And this is very much embedded in the world of the Council of Europe, which is in turn explicitly aimed at securing democracy in Europe. So this focus on democracy, maintaining an effective political democracy, that it depends upon human rights, and that there is a like-minded heritage of traditions, ideals, freedom, and the rule of law, is very central to the way in which the European Court in this case tries to deal with arguments that this is not a matter for courts, that courts shouldn't be dealing with, particularly human rights courts, shouldn't be dealing with climate obligations, that this is a matter that has to be dealt with by governments. That's an argument that was being made very strongly by Switzerland. And indeed, after this case is handed down, it continues to be made very strongly by Switzerland, but all the other member states of the Council of Europe have supported this judgment, in which two groups of applicants brought a claim that that Switzerland had failed to protect the rights of these senior women, the right to a fair trial, the right to respect for private and family life, because of its failure to take actions to mitigate its climate emissions. two groups of people brought this claim. One was an association, a collective representing 2,000 women over the age of 65, and the other were 4 specific individuals. So what was very interesting about this case is that the European Court of Human Rights has 36,000 cases before it per year. And again, it couldn't really deal with being the climate court for the world. But on the other hand, it felt very strongly that it had a role to oversee the conduct of democracy and participation in decision-making about climate matters within Europe. So I can really recommend this 300-page, 200-plus page judgment. We have not much time left, so I'm not going to attempt to kind of characterize it here. But suffice to say, one of the ways in which they squared the circle was to talk about the role of courts in ensuring that people can participate meaningfully in making decisions about matters of life and death. And also in thinking about specifically the role of associations, of groups of people, of collectives in bringing action. And they found a way to make standing for an association. So indeed, they didn't find that the 4 individual victims could bring an action, but they did find that the association could. So as we think about ways in which human rights can be used in a way that moves beyond individualism, I think this case is a very interesting example of a court that has the authority to make that kind of move. Okay, in the time left to us, let me move to the question of, this is why slides are not good when you have way too many and you are way too ambitious about what you can talk about. Final point, the rights of environmental defenders. Now, I think this matter should be really treated with as much attention as all of these other cases that I've talked about. Now, those cases are enormously important because we have seen standing thought about in expansive ways that are bringing issues before these courts. We have seen now courts make a finding in terms of a failure to adapt and a failure to mitigate. But there is less attention being given to cases to do with climate protests. So I am not finding many multi-day seminars or many journals that are kind of writing as much about these climate protest issues as we're seeing about these other cases that are kind of focused on much more bureaucratic matters. Now, I'm not trying to say those other cases are not important. I think they very much are. But to go to this question of the different roles that human rights can play in relation to climate action, let's finish by looking at the rights of environmental defenders. Because we know that an environmental defender is killed every second day around the world. There's increasing suppression of climate protests and a limit to what people can say in their defence in court if they've been charged with a crime related to climate protests. So in the UK now, the plea of necessity or trying to persuade the jury that they would have supported the crime was getting up, was being successful, and now that's no longer allowed to be put to a jury. There are also issues in relation to participation and protection of protests at COPs, at the conferences of the parties, which over and over again now are being held in authoritarian petrostates. And to date, there are fewer regional or international law cases dealing with this. So there are some. That one is hidden under that screen sharing thing, but Dumanjad in France was brought before the European Court of Human Rights in relation to the 2015 COP that was held in Paris. You'll remember that the attacks on the Bataclan and other places were around the same time. An emergency decree was put in place and it was used to reach out and stop some people participating in the COP. And the European Court found last year that that was not brought within the scope of the emergency regime, that they couldn't use the emergency law to do that. And in Friedrich and others in Poland, a case concerning the 2019 detention of 16 Greenpeace activists and 2 journalists was also found to be a violation of right to liberty and security of the person and freedom of expression by the Polish border guard. There are also numerous cases that I can see working their way through the Swiss courts, really quite a lot of cases. There's a lot of protest and sabotage going on in Switzerland, and it is all now working its way slowly through the courts, and I imagine some of those cases will end up before the European Court. And I also think we will see some cases from the current situation in the UK appearing before that court because defences are being including human rights pleas in those defences. But we've also seen the Human Rights Committee in its general comment on the right of peaceful assembly make a number of very strong statements about what Article 21, remembering this does apply to every state that's ratified the ICCPR, collective civil disobedience or direct action campaigns come under the right of peaceful assembly. Disruption or unrest, such as mere pushing and shoving or disruption of, say, vehicular movement, does not amount to violence. To be considered non-peaceful, an assembly must be characterised by widespread and serious violence, not just a little isolated acts by some participants. To characterise the whole protest as non-violent, it must be much more widespread. While restrictions imposed on assemblies may be necessary for the protection of rights and freedoms of others, assemblies are themselves a legitimate use of public space. And since they may entail by their very nature a certain level of disruption to ordinary life, such disruptions must be accommodated. In Europe, there is also a convention called the Our House Convention, which was negotiated in 1998. And ratified by 48 states, which, amongst other things, provides that there must be, in order to have a right to the environment, there must be access to information, public participation in decision-making, and access to justice, and each party shall ensure persons exercising their rights in conformity with the provisions of the Convention shall not be penalised, persecuted, or harassed. And in 2021, the parties to that convention, which is most of Europe, established a rapid response mechanism in the form of a special rapporteur whose job is to protect environmental defenders. His name is Michel Forst, the first appointee to that job, and I can just really strongly recommend looking at his work. He is a man with a great deal of energy. He is intervening in many cases in Europe. He has a position paper out on state repression of environmental protest and civil disobedience, a major threat to human rights and democracy, in which he says, amongst other things, the repression that environmental activists who use peaceful civil disobedience are currently facing in Europe is a major threat to democracy and human rights. The environmental emergency that we are collectively facing and that scientists have been documenting for decades cannot be addressed if those raising the alarm and demanding action are criminalised for it. The only legitimate response to peaceful environmental activism and civil disobedience at this point is that the authorities, the media and the public realise how essential it is for us all to listen to what environmental defenders have to say. He now has a set of guidelines out on peaceful environmental protest, very much worth your attention. I think it's an extraordinary piece of work. It summarises what it means to engage in civil disobedience. It summarises all the international and regional human rights law on that question. And it proposes all sorts of things that states should do and basic principles that should govern how states respond to climate action. They must look to the root causes of the protests, take immediate action to counter narratives that portray environmental defenders as criminals, including, for instance, through engaging with social media. They must not use the increase of civil disobedience as a pretext to restrict civic space. So to conclude, I think David Kennedy in 2002 calling for us to be pragmatic, I think that is still important. But I think it's also important to pay attention to the situation in which that critique is now going to work. And I think climate activists are very savvy indeed about using rights and litigation as one aspect of a much broader field of law and of politics. This is not a naive faith in law. This is a very savvy use of the law. I think human rights play multiple roles as part of climate activism today, and they're significant and valuable in many different ways. A great deal of attention is being given to cases that put pressure on states to adopt more ambitious targets and the kind of bureaucratic work of the UNFCCC. I think that is very important in terms of expanding participation in that decision making. But impressionistically, I think there is less attention being given in the academy to issues to do with climate protests. And I think we see that in activism, the powerful campaigns like campaigners like Global Witness, protecting environmental defenders, the art of protest being refined by Greenpeace, by Just Stop Oil, by Extinction Rebellion. But I think in some ways we're perhaps more comfortable as lawyers imagining ourselves engaged in policy, at least some of us, rather than engaging in protest, or as in causing good trouble, as I think your Senator Booker would say. But the legal academy needs to give as much attention to issues of the right to free speech, the right to freedom of peaceful assembly, the right to peaceful protest, and the right to a fair trial as it gives to this question of regulation, because meaningful climate action that's just and effective is not, I think, possible without meaningful democracy. Thanks.
Thank you very much, Professor Orford. I'm going to open up the floor now for questions because we're running a little bit behind on time. We're going to limit it to 3 and only the folks who are here in person. So I will bring you the mic if you've got a question. But yeah.
Hi, thank you so much. I'm Sharmila Murthy. I'm a professor here at Northeastern, and a really interesting talk. My question is really about how you see building on this idea of being pragmatic. What is really the pragmatic impact on the actual jurisdictions, like in Switzerland? Like, what was the actual impact? And then, given the climate we're in right now in the United States, do you actually see perhaps a different kind of impact happening, i.e. a jurisdiction like the US saying, this is even greater reason why we want to be retreating from the international stage, because we don't need some actors in Geneva or wherever telling us what to do?
Yeah, so I think it's a great question, and that's, you very much see that playing out. So in the case, if we think about the example of Switzerland, so the reaction in the Swiss Parliament was quite negative. The Swiss Parliament, in fact, voted not to follow that decision. But of course, it's not up to the Swiss Parliament, so they didn't get to make that ruling wasn't binding on anyone. It was just a show of outrage. And it was a little tough on Switzerland because 3 cases were handed down on the same day. The other 2 didn't get up. The one against Switzerland did. It's actually quite a good actor. So, it's like, why us? And so I think that was in some ways unfortunate. So there was it's the kind of backlash that you could imagine coming particularly from people on the far right saying this is exactly why we shouldn't be part of these things. It's harder, I think, in Europe to withdraw from these human rights treaties. It's so much embedded into the fabric of European culture in the ways that I used the preamble to try and show. But I think it's very striking that the Council of Ministers all, so then there was a meeting just a couple of weeks ago where the Council of Ministers then had Switzerland in front of it and said, what are you doing to respond to this judgment? They handed up basically a report of what they'd already done, not what they were going to do in response. And the Council of Ministers said, well, that's not enough. So we need you to go back and do all these other things. Or to go back and it's up to you to show us how you're going. We're not going to tell you exactly how to comply with this judgment, but you haven't done it. And just this pretense that you're going to give us what you're already doing, that's not enough. And I think it's very interesting that all the other ministers of the European governments could at that point have said, actually, we want to join with you and say the court went too far. That's not what they did. So I think that was an interesting moment where you see that this has legitimacy within Europe. And that the court had managed the situation well enough. They had still left a lot of space for Switzerland to decide how to comply with the judgment. And if we think about the case of Australia, the Billy et al. Case that I suggested to you, that's also an interesting example because it was brought at a moment where we had an extremely conservative government that didn't admit climate change was a thing. Imagine a government like that. And they were went very strongly against that. It was quite an aggressive response to the claim. And then the reaction was from a different government that for the first time in my memory did say we as Australians had to address an issue of climate change, and they reacted quite differently. So they still had some issues with the judgment, but with the opinion, but they were much more kind of deferential and respectful of the process. And in some ways it was, I think, important and helpful to have these kinds of decisions coming internationally to help support what had become a really, really significant green shift in Australian politics, partly in response to extreme weather events, which you all probably saw of flooding and fires. So yes, of course, it can have that effect, I think, but that is built into this whole struggle, and this is no different.
Hi, my name is Rachel. I'm an incoming student at NewSol. Hello. And yeah, one of the concepts that really fascinates me is the concept of standing, especially in international disputes. And I read Christopher Stone's piece on Should Trees Have Standing? And I was wondering if you have any thoughts on, is that something that's feasible for the international community? Are we moving towards the idea of the environment itself having standing, or a guardian that could bring suits on behalf of the environment?
Great. Yeah. So there's a lot of attention given to this idea of rights of nature, and we do see it in an increasing number of domestic legal systems are beginning to give standing to nature or to rivers, or specific rivers. Or at this point, for me, I can't imagine it getting up under some of the conventions I've been talking about. But the Inter-American Court is much more creative, much more interesting in some ways. And they're about to hand down a very expansive advisory opinion on climate change and human rights. It has an open standing system, unlike some of these other courts and tribunals. So many more parties have participated in those hearings that were really quite, again, they found a way to have many more types of people involved and participating. And I think that's going to be a really interesting advisory opinion. I don't think it will do anything on those questions, but I think it is likely to kind of think more expansively about some of these issues. The other way in which the Christopher Stone piece on Do Trees Have Standing is interesting is that Philippe Sands said it inspired him in some ways to think about ecocide. And so ecocide, the way it has been proposed, has this quality of being about trying to represent something other than humans. So we'll see whether that gets up, and there are all sorts of ways in which humans sneak back into that definition. So, but it still is a little less anthropocentric. Yeah.
This is going to be our last question.
Thanks. So thank you so much for a wonderful talk. And this is a little bit unfair because you're an Australian lawyer, not a U.S. lawyer, but that's my question is about what we see happening in the U.S., which is much of the climate litigation that's been successful to the extent it's been is at the state level, not in federal courts. And to what extent do you think human rights has a role to play in litigation at the subnational level?
Yeah. So I think that's a very good question, and so I will very much plead to to the point you make. I am not in any way an expert on the US legal system. My students are very enthusiastic about these questions, and a lot of them are taking other courses on, including Tyler Giovanni's great course on human rights and climate litigation. So that's not something I work on, but I think it is interesting to think what the barriers are here. I think it's to do with the very different way in which the courts are structured, the way in which kind of constitutional issues are interpreted. But I do think it's interesting not only that things are happening at state level, but that the states are also the initiators of a lot of these questions. So that's in some ways less a human rights story, but I think you could easily, I think we will see a lot of this developing along the lines of tobacco litigation and of opioid litigation. So I think we're going to see attempts to hold some of the actors responsible. And we're also seeing this internationally. We're seeing it through, I think the International Court of Justice is going to make some findings on questions of responsibility in its advisory opinion. I very much think we're going to move into an era where we start seeing reparations, whether it's through domestic or international law. And I think that's, so I have just handed in a paper on this to the American Journal, which has a symposium on reparations coming out, dealing with all sorts of things, but including climate reparations, also colonial reparations and reparations for slavery. And in that piece, I argue that you can't really have, you negotiate in the shadow of what you think the background rules are. And if the background rules are not being properly, clearly articulated to ensure that those who are responsible for this transboundary harm are bearing some of the cost, then it distorts all the negotiations. The negotiations are all kind of, it's as if nothing's at stake, but something is at stake. If you keep polluting, then you're going to be responsible for it. And until that's on the table, I think the negotiations will remain stuck.
We have one more question and then we'll be done.
Hi, thank you so much for speaking to us. I really appreciated your attention in the last part of the presentation to the protesters issue. I noticed kind of the recurrence of sort of this notion of peaceful protesting. I know that a lot of climate action groups take actions that might not be considered peaceful. Do you think that there's room within a human rights framework for that form of protest, which is kind of so often accompanied these other protest movements that are a part of the democracy and the peaceful protests that sort of get glorified after the fact?
Yeah, so there's a lot of attention given to, and if I had more time, we would go through those slides much more slowly, to what it, to the degree of disruption that can still be kind of brought within the notion of peaceful. And I think what the kind of human rights special rapporteur is trying to do is push back against this idea that any disruption, including gluing your hands to something or, that kind of disruption is violent, is in some way violent, and trying to push states to not think immediately repressive criminalization of those kinds of actions. And I think in some ways, from what I've been reading in the press of late, I think it may well just be going to escalate things in some ways. So, there's a piece in The Guardian a couple of days ago that that some of the groups are saying, well, we can't have any form of peaceful protest anymore, so we're going to move to things that aren't public, to forms of sabotage. And I think that is, if you keep just shutting things down, I think one of the points Michelle Forst is trying to make is, you need to make space for people to be able to protest, because this is an emergency. So this is existential, particularly for a young generation. It's all right for 85-year-olds deciding nothing should be done. Well, they're not going to be here this much longer unless some other form of development is underway that I don't know about. But for young people, of course, it's existential, and trying to be heard is important, I think. Yeah.
If everyone could please join me in giving a hand to Professor Orford. Oh.
Thank you very much. Oh, beautiful. Thank you.
Okay. Christian Lamar is a NUSWA and BALSA alum from the class of 1993, and he's also Valerie Gordon's husband. Christian leads a busy life as a supervising attorney at the Metro Capital Defender, but he makes time every year to attend this event in his late wife's honor. Christian is a dedicated BALSA alumni and will even be supporting BALSA by sharing some of his words of wisdom at our 3L send-off in a few weeks. So everyone, please join me in welcoming Christian Lamar.
Good afternoon. It is always a blessing and an honor and a joy to come back home. I never thought I'd ever say Boston was my home. All right. But Northeastern is home for many reasons. And I think the spirit that is here today is witness to that. I want to start out by just giving thanks uh, to Northeastern Law School, to the university. But as we know, the institution is only as great as the people who design it and define it and build it. And I don't want to pile on, but I am going to pile on because I want to give David so much thanks and credit. Not only did David and Hope institute the lecture, but David, in essence, shared the eulogy of Valerie. He came to Kansas City and gave a very moving tribute to Valerie. It was a horrible time. The greatest joy was this young man here. And David has stood with me personally for the last 30 years through the ups and downs of my career, my life. He and Marilyn have always been there for our family. Carolyn she's at the doctor's. Basically, she had an accident on campus. She is gonna be okay. She's recovering. So Dr. Gordon definitely wanted to be here. I'm gonna make sure she gets a good lawyer. Uh, and she wishes she could be. So I'm glad we're recording it, but just want you to know that she's gonna recover and she's gonna be okay. But Northeastern, David, this whole family has been with us and our family throughout these past 30 years. And I am so thankful, and I represent the thanks of all of our family, all of our friends. It's so funny. I may say Nisi. That was Valerie's family name, Nisi. So sometimes I go off into that. But kind of like with David, with Marilyn, I was just talking to David earlier today that, we met here at Northeastern. And I don't think we're the first couple to, I'm sure there have been other couples before and afterwards because law school happens, a lot of pressure. And so, like, whoa, I think I need to talk to this woman because maybe she can help me make it through this. And our classmates would tell us that there were many times in that dorm when Valerie's joy and cooking and laughter and our togetherness helped us make it through that first year. But in speaking with David, I think it's very interesting that, and I was telling Feluke that our first date was me trying to impress her with my Black history knowledge. We actually went to the jazz club on Massachusetts Avenue that, if you read the autobiography of Malcolm X, that was a club that he had frequented. And David reminded me of that today. And I said, oh my God, that was our first date. That was where I took it. I was like, yeah, I know some stuff. Of course, she was a woman that you needed to impress. I mean, you had to come strong, all right? Had to bring my A game. Thankfully, it worked. And fortunately, I've had the joy and the pleasure and the blessing of being loved by such a wonderful woman, and a wonderful woman that blessed me with a wonderful son and upgraded me so that I could go on. And I remember Marilyn and David kept checking on me like, you're gonna be all right, you're gonna be all right. And then Valerie trained me so that I could meet another wonderful and beautiful woman who wasn't able to be here today because she's being a head counselor in a public school in DeKalb County, doing her thing there with the kids. And they've been there for us too. Shannon Lamar is my wonderful wife and partner and life partner. And throughout this journey, not only in terms of my family, in terms of Feluke and Carolyn and my wife Shannon, who is just the rock of my life. Also, I was telling Marilyn, and Feluke, would you step up a little bit? So, folks, I'm talking about you. This is Valerie and I's son. As you can tell, he took on her height. All right. But I also we have 4 other children. Feluke has 4 siblings. Carlin, who has just produced a grandson, Blake. And then Feluke has 2 children, Khalil and Valerie. His daughter's named Valerie. And then Shannon and I have Amir and Amina. And they have Northeastern has embraced our whole family, our whole blended family. And this is a blended family that we have. And that is why I love so much coming back here. I think that the lessons that I've learned over these past 30 years keep coming back to here, keep coming back to the community that we had. I was speaking to a couple of the law students, and I was saying, you know, coming in, we had to have each other's back because, you know, I know people have heard about the whole imposter syndrome sometimes that folks go through who come from different communities, whether you're poor, if you're different. You need someone that's telling you, you are okay. Because even though these institutions may be welcoming, sometimes you have to force it. And that's when David talked about Valerie being part of a push to make, as Dr. King said, cash the check that we're owed. And that's what we tried to do with Northeastern. And that is what I believe that we should all continue to do. I told Feluke, I said, well, you can say a few things on behalf of Auntie, and that's Dr. Gordon. So I'm just gonna turn it over to him for a couple of minutes and then I'm gonna finish up.
Just wanted to say thank you on behalf of me, my aunt Carolyn Gordon, all of us. It's always such a joy and honor to come. Never had much of an interest of being a lawyer, but I do like coming here. It's just such a great atmosphere. I feel all the love and appreciation, and just seeing other Black and Brown people doing the thing we don't see Black and Brown people do a lot. You know, it's always very inspiring. So I remember coming here as long as I can remember, and so I love it. I always look forward to it every year. So as always, thank you, and I'm very appreciative to be here.
And one of the things, you know, we talk about legacy and we talk about tradition and we talk about what has been put forth. Well, Valerie was an activist before she got here, right? So was I. But you go to places that hopefully upgrade you and push you, and then you pass it on. And so, you know, I'm gonna brag a little bit about this young man. You know, he's a great father, absolutely great father. Like David, I tried to raise him to be a scholar athlete. He played Division I football at Indiana State and then at Mars Hill. And was it 2014? I think the film is still alive of Black Lives Matter protests in Atlanta right after the Ferguson decision. Police attacked our son and beat him down. And for about a whole night, we didn't know where Feluke was. His sister called me because she was there, and she screamed when the police basically attacked him and took him off. And I spent that whole night driving around the different detention centers trying to find him. He had been put in the back of the van and driven around. So he came by it honestly, and he survived that, and he still stands strong as a powerful and conscious and woke Black man, and I'm not afraid to use that word, because that's the legacy. When he first came in, one of the first lectures, I don't know if you remember, David, was the Chief Justice of South Africa, who had been a revolutionary, and his name escapes me, but he gave Albie Sachs. So those are the kind of people that Northeastern has brought. Randall Robinson, all right? Albie Sachs. Albie Sachs gave you that copy of the South African Constitution. And so what happened with Antoinette, and somebody in this audience right now is going to be inspired to move forward and to carry the struggle on and to carry this legacy. So this community is so special. It's so unique. It's a gift to the legal world, and it's a gift to the whole world. Thank you all very much.
As we conclude today's event, we want to extend our deepest gratitude to everyone who made this event possible. Thank you to all our speakers for traveling far and wide to share some words of wisdom with everyone today. To Ann Orford and Dean Hall, we really appreciate it. We want to say thank you to the Gordon family for your continued support in keeping Valerie's legacy alive. We want to say a special thank you to the Center for Global Law and Justice at NUSL, in particular Elizabeth, for all your behind the scenes work in making this event possible. Your dedication and effort were truly appreciated by BALSA and by NUSL. I know Sydney and I were discussing that we don't think we've ever met anyone as organized as you. So it truly has been a pleasure working with you. Before we wrap up, we want to invite everyone to stay for the reception immediately following this. It's a great opportunity to continue the conversations that we've been having all day, to connect with one another and honor Valerie's legacy together. Thank you all again for being here, and we hope you enjoy the rest of the evening.